Yeah, fine. I'm just thinking because the charge sheet says at or near. People don't interpret that. Just read the charge sheet. It says the offense happened at or near Fos Luras.
Yes.
Just read it. It doesn't say it happened at Fos Luras. Let's read it so that this ghost can jump off my back.
I am back with another painful edition. Yes, I know. I've taken note. I've heard your complaints in the comment section, but it is what it is. Okay, we have to do these reviews so that when my lord sits there inside the court and he reads his ruling, not judgment, his ruling for section 174, and then he's citing things that Badloyi said inside Pagat, his response to Advocate Zitulele Nxumalo, which wasn't really a response to him because he was just going off on tangents. Okay, he was off ramping. If there's one thing I can tell you about everything Badloyi did, it was a total off ramp. You see, a response means you reply what Nxumalo did. Advocate Badloyi did not reply to Nxumalo. He just came with his own off ramp points that he wanted to put to my lord. And so in today's video, we did already Ubongani Danzi. We also did a live. Thanks to everybody who joined the live yesterday on Sunday o'clock. Welcome, welcome, welcome. Thank you so much for the Sunday support. We did it, guys. We did it. The live is available, okay? The replay is still up. Go ahead, catch up, because I think it was really fun, okay? In my personal capacity. But in today's video, we are going to go over part 2, which is now when Baloyi goes into Muzi Sivia's confession and the pointing out. Notice how weird that is. Okay, why didn't Baloyi start in chronological order? Start with accused number 1 and then move to accused number 2. I don't know. This is how Baloyi operates. Okay, very random, very off-rampishy. Okay, so we are following his structure. Today we are covering Muzi Sivia, but take a look at your screen. Take a look at Ubongani Danzi. Ubongani Danzi looks like he's so done with everything. He is just so done. He is upset. He cannot believe his ears. It is just so shocking. So we're now going to go into part 2. Muzi Sivia's alleged confession. That's what we're going to call it, okay? Over there inside Judge Ndim's courtroom. If you don't know who Judge Ndim by now is, listen, I've got a whole playlist. And I told you at the time when I was covering the Jocelyn Smith case that follow it even though you are not familiar with the case. Just follow it anyway. Because guess what? We learned a lot from that case. In Judge Ndim's courtroom, although he accepted the confessions, he said he was not going to call them confessions. He started to call them statements. And that's how he treated them from the admission all the way to sentencing. Yeah, he literally called them statements the entire time. But let's jump into it. You already know the house rules. Like, comment, subscribe. Okay, check if your family members are subscribed to Mzansi Unfiltered because yeah, we've got a milestone coming up, okay? And we can only do it with your support. Hit that like button. You know the rule. If at the end of the video you don't like it, go ahead, take back your life. And I appreciate you. Let's jump into it.
Confession and pointing out the house of the Kumalos and where they were dropped off near the hostel. Accused number 1 stated in his confession that they consulted a traditional healer before they committed the crime and afterwards went back to the traditional healer for cleansing. The traditional healer, Mr. Lionel Zwani, testified that accused number 1 came to see him in the company of other 2 persons whose face he couldn't see. And he mentioned that accused number 1 also at the later stage, referring to the events of the 30th of May, that he came with the police at Eraton and he identified him as the person who came to consult him in the company of 2 other persons to be successful in their exploits and came afterwards for cleansing and mentioned that things went wrong and someone had died. Paragraph 8.17. Accused 3, 4, and 5 were arrested on the strength of the confessions of accused number 2. And a firearm was found in possession of accused number 3 in the house where that he rented. And this firearm was connected to to the offense in the sense that the bullet projectile that was found on the scene matches that firearm. And the cell phone downloads show that accused number 5 spoke to Kelly Kumalo on 2 occasions, the 2nd or the 3rd of August 2014 and 15 October 2014, not long before the incident, 26 October 2014, paragraph 8.18. Accused number 3's cell phone records place him in the reception area of Foslores Tower, which services the nearby Basotho Hostel on 26 October 2014, which is corroborated by Zungu's evidence. Paragraph 8.1, accused 3, 4, and 5 concede that they were together on the 26th of October 2014.
I remember one thing that Judge Ndim said in his courtroom is that he was always observing the body language and the demeanor of the 3 accused, Buta, Steffi, and Kelly Smith. So basically, why am I bringing this up? Look at the body language of accused number 3, 4, and 5. They're literally laughing away, they're giggling. Very different body language in contrast to Ubongani Ntanzi, who looks quite enraged, disgusted when Baloyi was going over accused number 2's confession, alleged confession. Why am I bringing this up? Because keep in mind, last week was a very, very different kind of week, okay? The accused did not get any interpretation on the same day that things were going down in the court. So as Baloyi is presenting, the 3 are laughing away, okay? What is kind of ironic, the moment that they're laughing away, which means they're so disconnected from the proceedings, it's when the Baloyi is saying that the 3 of them, okay, were together on the 26th of October 2014. And my question to you is, if you're together with your friends and there's an unaliving event that occurs on the same day, does that automatically make you a suspect? Or in this case, does that actually make you the person who went out and took the life of SENZO MEYIWA? One other thing is that for the state, in order for the state to strengthen their struggling evidence, that's where I believe, in my opinion, Zungu became a pivotal role. They were willing to throw all of Zungu's work commitments, work obligations, that they were willing to throw Zungu under the bus. And Zungu was also willing to be thrown under the bus in order to strengthen this case. One, he knows the 5 accused, according to him, from the homelands. 2, he was with them that night, partying with them while he was driving a state vehicle, okay, and had his state-issued firearm, which he handed to Gwavini, and so on, and so on, and so on. In other words, where is Umkhwanazi to come and take Zungunizer, okay, and just take him just for that confession alone? Because that is a breach of the SAP's work provided vehicle use. He went partying in a work vehicle. Someone also put in the comments, well, he told us all about all the drinking that he was doing. So he drove that vehicle intoxicated as well. And then he submitted his firearm. He willingly gave his firearm to an Inkabi. How do we know that his firearm is not the one that was used in the commission of the unaliving? Let's go with his theory that the 5 accused then left and they went to the Spaza home. They pew-pewed Senzo, and then they came back. And now I'm wondering, why didn't Gwabeni go? What was he busy doing? Okay, but let's continue listening on, because, it is the struggling state case with the struggle evidence. Let's hear what else we can pick up.
Paragraph 18.20. It is considered that the confessions statement by accused number 2 constitute hearsay evidence against accused number 4 at this stage. And in light of the decision of Ditako, which we'll refer to in due course, there is no longer any need to distinguish between confessions and admissions. They are both regarded as out-of-court statements, and the term that's used in South Africa is extracurrial statements. The only question is whether the hearsay evidence is admissible at this stage, paragraph 9.
Sorry, is it correct?
Well, in the sense of Section 219.
Yeah,
We'll
I'm with
refer
you.
to Section 219.
I'm just saying
yes.
that issue is not settled in our law.
Yes.
Remember, there's a huge debate
Yes.
about that Goldstein, my brother, we used to be together in Joburg, the case of State versus Ndlovu,
Yes.
Anta Halter, Litako, and then there's an acting judge, Davis, in the Cape. There's still a debate about whether it's appropriate to accept Section 3
Yes.
of the Evidence Act, in the sense that you make a ruling that it's in the interest of justice to admit certain evidence, like you are arguing,
Yes.
even if it deprives an accused person from cross-examining. Are you with me?
Yes. Yes.
Am I correct that
yes.
issue has not been settled in our law?
Yes,
Yeah, fine, okay.
indeed, my lord. And as
Yeah.
we go along, we'll be referring to
Yeah.
Himstra, where he says this rigid approach should be jettisoned. In S versus Mulimi, 2006, Volume 2, SACR 8, the decision of the SEA at 9, paragraphs B to D, the SEA held that, and we quote, however, while the rule against hearsay was rigid and inflexible, the Evidence Amendment Act 45 of 1988 Act had created more supple standards which allowed the admission of hearsay evidence if it was in the interest of justice. But this runs counter to Section 219 that we will refer to.
Yeah. Except that in Canada, the position there is static, except that they equate it to our Section 35.
Yes,
Are you with me?
yes, the federal rights of the accused.
Rights, yeah, the rights of a fair trial to an accused, whether it can supersede Section 3 of the Evidence Act.
Yes.
Those reasons which make you decide that it's in the interest of justice to allow certain evidence, despite that fact. I think that the case is what? State versus, not the Canada case, the ones we allude to. It's that case of the robbery of 34 million rands in Natal. You remember the State versus,
Is it not this one that...
I think it's Pune. Anyway, that case, what happened in that case, there's a lady who was, an Indian lady who was part of the group which robbed the Fidelity Fund money. They were listening unlawfully so. They were monitoring her calls. They confronted her with the calls to say, we know that you were involved, your husband and so on, they were involved. And then she confessed. And then they said, where is the money? Then she went and showed them the money inside the ceiling. You haven't read that case?
Yes. Well,
The writers, Dos Mutata,
Yeah.
Mpati, etc. Anyway, fine. But I'm saying, in that case, they say there are instances, like you are trying to argue,
Yes.
where, for instance, the interest of justice, even if that evidence is unlawfully or unconstitutionally acquired, the interest of justice can demand that that evidence must be made admissible.
Admitted, yes.
That's it, yeah.
And we continue down the rabbit hole titled The Struggle Evidence. That, ladies and gentlemen, is my Lord saying, yeah, in the interest of justice, we can demand that the evidence be admitted, even though it was unlawfully obtained. Well, you don't think he just brought that up on a random whim, do you? So we're clocking it here on Mzansi Unfiltered. That's going to be very, very interesting later on when he reads his ruling. Is he going to come back to tell us about this unlawful evidence and done that was admitted? So technically, Zungu's statement, okay, the one that's been read inside Pagati within the court was unlawfully obtained because Zungu says he's not a part of it. Okay, he doesn't know about it. So what is my Lord going to do about Zungu Senior's statement? About Zungu Senior's statement, because Zungu's out on these YouTube streets saying, I don't know Kininda like that, okay? I've never been to Pretoria. Mark my words, we're going to come back to this, but let's continue listening on. Yes, it gets more interesting.
Yes, we'll be referring to the case of Korashi, which is
Korashi,
in the same vein.
All right.
And paragraph 24, It says, well, we'll start again on paragraph 9. However, while the rule against hearsay was rigid and inflexible, the Evidence Amendment Act 45 of 1988 Act had created more supple standards which allowed the admission of hearsay evidence if it was in the interest of justice, provided that the reception of such evidence did not surprise the accused. Well, we argue, my lord, that accused 4 wasn't surprised by the evidence. It was dealt with at great length in cross-examination, or come at a stage in the trial when the accused was unable to deal with it. Further, the court had to ask itself whether, in the circumstances of the case, the reception of the hearsay evidence was unfair to the appellants and therefore not in the interest of justice. And having regard to the factors enumerated in Section 31C of the Evidence Amendment Act, the court held that there was no doubt that the admission of the hearsay evidence contained in the first accused's extracurricular statement was in the interest of justice. The statement had been made soon after the accused was arrested. His subsequent disavowal of the statement was correctly found to have been untruthful. Evidence of the contents of the statement had been tendered by the state to explain cell phone records also placed in evidence. These records have confirmed the probative value of the statement, and the tendering of this evidence had come as no surprise to the appellants. They had been able to deal with it inter alia by cross-examining the accused. The court ruled that there had been no prejudice to the accused, and fairness of the trial had not been compromised. And that will be our argument in this matter as well, my lord. Paragraph 10, we mentioned that Mr. Bongani Ntanzi, accused number 2, was arrested on 16 June 2020 and made the first statement soon thereafter on the 19th of June 2020. He then made a second statement before a magistrate in the presence of his attorney on 24 June 2020. Paragraph 11. The statement is corroborated by the eyewitnesses as to how the incident happened, his presence in the house, and the gun-wielding, dreadlocked attacker, whom accused number 2 has identified in his statement as Carlos, accused number 3, how the deceased was shot, that 2 shots were fired in the house, which accords with the findings of the ballistic expert, Lieutenant Colonel Mangena, that the deceased was shot at close range, which is again supported by the ballistic expert, and the findings of the pathologist, Dr. Steenekam, during post-mortem. Dr. Steenekam testified that this was a contact shot. A firearm that was subsequently found in the possession of accused number 3 is ballistically linked to the bullet projectile that was found on the scene. The cell phone records of accused number 3 show that he was within the reception area of the Fossilores Tower on 26 October 2014. Accused number 3 and 5, out of their own beds, concede that they were all together on the 26th of October 2014 in the vicinity of Fossilores. Cell phone downloads show that accused number 5, whom accused number 2 mentioned in his statement, contacted Kelly Kumalo on the 3rd of August 2024 and 15 October 2014, paragraph 12.
So
We therefore, yes,
I'm
sir.
just thinking wildly. You are saying accused 2, 3, and 4 admit that they in the vicinity. Is it 2, 3, 4, or what?
No, it's 3,
3,
4,
4,
and 5.
and 5.
Yes,
They make the concession
yes,
that they were within the vicinity.
yes. They say they were having fun traveling in a combi.
Yeah, fine. I'm just thinking because the charge sheet says at or near. People don't interpret that. Just read the charge sheet. It says the offense happened at or near Fossilores.
Yes.
Just read it. It doesn't say it happened at Fossilores. Let's read it so that this ghost can jump off my back.
Wait, guys. Can somebody please tell me who is the ghost that needs to jump off the judge's back? Who is bothering my lord?